Hello everyone, welcome to UPSC Wise. Today we're exploring a colossal, centuries-old system impacting millions in India, Waqf. After the Indian Railways and the Indian Armed Forces, there's a third major property holder in India managing assets valued at thousands of crores. This system, called Waqf, is deeply rooted in history. We'll break down the controversial 2025 Waqf Amendment Act and the Supreme Court's recent interim order, explaining what was put on hold and what remains in effect. This isn't just about statutes and courtrooms. It's a profound story about community property and the very definition of faith within a secular state. So what exactly is Waqf? At its core, Waqf is an endowment of property dedicated for purposes considered pious, religious, or charitable under Muslim law. Think of it as property dedicated to God for the community's benefit, an enduring form of Islamic charity. Once designated as Waqf, a property becomes irrevocable and immune to sale or transfer. It's meant to be permanent. It's a living expression of community life, supporting religious, educational, and social causes. The core purpose is charity. This concept isn't new to India. Its legal recognition dates back to the 1923 Musalman Waqf Act, formalized later by the 1995 Waqf Act. The sheer scale is staggering. We're talking about an estimated 870,000 properties across 940,000 acres, valued at around 100,000 crores or roughly $12 billion. This immense scale highlights why Waqf administration is such a crucial and often contentious national issue. For proper management, every Indian state is required by law to constitute a Waqf board. However, the system has faced serious challenges. The 2006 Sachar Committee report highlighted widespread mismanagement and undervaluation of Waqf assets. At the time, these properties were generating income of only 2.7% of their book value, an incredibly low figure. This, along with ongoing disputes over land, encroachments, and undefined property statuses, set the stage for the 2025 amendment. The government's stated justification for the Waqf Amendment Act 2025 was to establish a secular, transparent, and accountable system. The stated aim was promoting efficiency, preventing unlawful claims, and modernizing governance. The original 1995 Act was even renamed the Umeed Act, which means hope. But the substantive changes went far beyond the name. One of the most significant was abolishing Waqf by user. Previously, long-standing undisputed religious use of a property could establish its Waqf status. The amendment removed this, now requiring formal registration for all claims. Even more contentious was a new rule defining who could create a Waqf. Section 3 of the amendment introduced a requirement for anyone creating a Waqf to prove they had practiced Islam for at least 5 years. Critics immediately called this discriminatory and an intrusion into personal faith, as no comparable condition exists for Hindu or Christian trusts. The amendment also granted district collectors DCs extensive new powers, including the authority to identify land as government property. A DC's declaration would immediately strip a property of its Waqf status, at least temporarily pending a court dispute. This meant an executive officer, not a judge, could effectively change a property's status. The composition of Waqf boards was also altered. It mandated including non-Muslims and allowed governments to nominate all members, replacing previous election processes. This shift to fully nominated boards, potentially with non-Muslims managing Muslim endowments, sparked deep concerns about community autonomy. Other new rules stipulated that land historically recorded as government property could not be treated as Waqf, regardless of centuries of community use, and excluded Archaeological Survey of India monuments and tribal lands from Waqf designation. On the positive side, the Act mandated digitization of all Waqf records and reformed the tribunal structure for faster dispute resolution. Given these profound changes, a legal challenge was inevitable. The Act was challenged on the grounds that it infringed upon fundamental rights to religious freedom and management of religious affairs guaranteed under the Indian Constitution. Many saw it as government overreach. The 5-year practice rule was slammed as arbitrary and religious policing. The expanded powers for district collectors were challenged as a violation of the separation of powers, as determining property titles is a judicial function. The abolition of Waqf by user and the new rule about government recorded land stoked fears of what many termed as silent dispossession, losing long-used religious sites like graveyards and shrines that may have been wrongly recorded during the colonial era. The bill's rapid 3-day passage through Parliament fueled perceptions of a predetermined agenda. A broad coalition, including prominent political figures and major Muslim organizations, filed petitions in the Supreme Court. While there was widespread protest, the reaction wasn't uniform. Some communities supported aspects of the bill. This brings us to the Supreme Court's response, a crucial interim order. An interim order is a temporary ruling designed to prevent harm while the main case is decided. First, the court stayed the highly controversial 5-year practice rule. It found the rule inherently arbitrary with no objective way of measuring personal faith and put it on hold until clear, measurable rules could be framed, if at all possible. Second, it tackled the DC's expanded powers. The provisions allowing a DC to unilaterally declare land as non-Waqf and order changes to revenue and Waqf records were put on hold. The court affirmed these actions violated the separation of powers doctrine, reinforcing that such decisions belong to judicial or quasi-judicial bodies. As a safeguard, the court also ordered a temporary freeze on the sale or lease of these disputed properties until a Waqf tribunal makes a final decision. Regarding board composition, the court capped non-Muslim representation on both central and state Waqf boards. It also issued strong guidance that as far as possible, the CEOs of state boards should be appointed from the Muslim community. However, what the Supreme Court did not stay is equally significant. Crucially, the court refused to interfere with the abolition of Waqf by user. That provision remains valid for now. The court reasoned that a legal requirement for registration has existed since 1923 and it deferred to Parliament's legislative intent to prevent potential misuse of the old doctrine. Also remaining in effect is the rule preventing government recorded land from being treated as Waqf property even with the history of community use. This means the legal risk of silent dispossession that concerned many communities remains. Other reforms like the digitization mandate, tribunal reforms and provisions excluding ASI monuments also continue. So what does all this mean? The 2025 Waqf Amendment Act is still largely the law of the land, but the Supreme Court's interim order has erected crucial guardrails against its most contentious elements. It has temporarily halted provisions seen as infringing on religious freedom and the separation of powers, while allowing the modernization and administrative reform aspects of the law to proceed. We must stress that this is an interim order, not the final word. The ultimate constitutional validity of this entire controversial law will only be determined after all petitions are thoroughly heard by the Supreme Court. The legal and political debates are far from over. This entire controversy powerfully illustrates a fundamental aspect of secularism in India. It's not just about keeping religion and state separate. It's also about ensuring that when the state does intervene in the affairs of religious communities, it does so with fairness, transparency, and crucial constitutional restraint. Which brings us to a final thought. Given these developments, what is the ideal balance? The balance between necessary state oversight for transparency and accountability, especially when managing vast public trust like Waqf properties, and the fundamental right of a religious community to manage its own affairs in a diverse, secular democracy. It's a question that goes right to the heart of what secularism means in practice today. Something to mull over. That's all for today's video. If you found this video useful for your preparation, then share your thoughts in the comments. Remember, the PDF notes for this video are on my Telegram channel. Link is in the description. Until next time, keep learning, keep striving. Jai Hind.